you have a question?
You had said that it's likely that you'll base the new legislation on what was before?
Well, stakeholders are telling us that that's the starting point for discussions. I don't know that the ultimate result will be a proposal for what we had before.
Do you have concern that you might lose the diligent search because Google has already scanned 2 million books and doesn't want any diligent search?
Yeah, so the comment was that Google has already scanned millions of books without performing a diligent search, and does that sort of change the dynamic for discussions now? I don't want to prejudge where our discussions are going to go. I will say Google's a major player, necessarily. I mean, they're a large player in this space. We work with them and need to take that into account as well. But it's a perfect segue actually into what I was going to talk about, which is mass digitization. This is probably the major way things have changed since we did the first study in 2006, is that somebody's tried to do this now. And the problem, of course, for entities like Google and anybody trying to do mass scanning is that doing the diligent search on every single work is not cost effective, right? And so it could be that from a policy perspective, it very well may be that the answer is, then you can't do it. But it also may be that there are ways we can craft solutions to allow entities to do that sort of thing, but to still figure out a way to compensate the rights holders properly. Because we're getting into this space, one of the drivers of the Orphan Works, so-called Orphan Works problem, is that copyright duration now is very, very long. And there are no notice requirements anymore for US works, at least. So you don't have to say on the work that it's copyrighted to get protection, right? That's just become sort of a standard, like we all understand that. It didn't used to be that way. And so the Orphan Works problem is increasing as more and more works are being created under the current law. You don't have to attribute, you don't have to put any copyright notice on there. There's a much greater likelihood that those works will become orphaned, particularly those where the rights owner may not be particularly concerned about their interests until such time as somebody wants to make some money off of it, and then of course they're interested, which is totally reasonable. It's just there needs to be a way to find them and a way to facilitate those uses. And it's just with the books, I mean, the Google Books thing is difficult because on one level, that's a really cool product, right? To be able to search the world's knowledge. If they did what they went all the way with it, they want to be able to make all of the world's knowledge searchable. That's a pretty useful tool. But they were doing it in a way that did not accommodate the exclusive rights of the copyright owners, and that's a challenge. And so really what we're looking at are ways of accommodating both of those interests. And so what we did, mass book digitization, we did a preliminary discussion document last October called Legal Issues in Mass Digitization. Not to disappoint anybody, there are no answers in this document, so don't read it thinking the magic answer's in there. It's really a framing document. We wrote that to sort of set up the questions and the issues for Congress. And in that, we go through at a very high level, some of the potential solutions, one of which is a compulsory license or some sort of collective license model. Compulsory licenses I alluded to earlier when I talked about the licensing division of the Copyright Office. In certain very narrow circumstances, Congress has identified markets that have essentially failed or have a significant imperfection in them. In other words, buyers and sellers are in a marketplace, but they're not coming together to do deals. There's something in the way of putting them together. Usually it's high transaction cost, right? Which is kind of what's going on with the Orphan Works thing. I want to scan all these books. I can't do a diligent search for each one. It's really expensive, and so it's a barrier to me doing this project. In a statutory license, what Congress is doing is they're saying, okay, we recognize there's a market failure. We're going to set up, using the public process, the legislative process, we're going to set up a license in the law that requires that works be licensed under certain circumstances. And to give you an idea of how narrow these are, 3 of the major ones relate to the retransmission of broadcast programming by cable and satellite operators. So you basically have a handful of major players in a space that are negotiating these deals within the context of a federal statute that helps them set rates and license terms. And those terms and rates are set by, in most cases, by Copyright Royalty Board, which is part of the Library of Congress. I'm not saying that model is a solution to mass digitization and what people want to do there, but it's a potential solution. So that, if let's say you did your search, or you paid some sort of license fee to scan things, and then owners would go to the Copyright Office or whatever the collecting society is, the body that collects the money, and they would distribute it. Lots of issues with that. That's sort of what Google tried to do in their settlement. They were going to set up a book rights registry, which was going to sort of serve as a CCC-like model. But that raises competition issues because you've got one guy in the middle setting prices for everybody, which is, back in the old days, we call that a cartel. So it's a risky proposition, but there are ways of doing it, potentially ways of doing it, that we'd like to think about and investigate. So this is an interesting read if you're interested in that discussion, but again, there's no answers in it. It can be a little frustrating because you get through it and you realize how complicated some of these issues are and how messy some of these discussions can be. I'll touch very briefly on exceptions for libraries. Back in 2008, we did a report on Section 108 of the Copyright Act. Is anyone familiar with Section 108 here? A handful of people. All right. So Section 108, at a very high level and very briefly, allows libraries to do things with works that are otherwise unlawful. Right? So they can make reproductions of works if the last copy of that work is falling apart. It has no provisions in it for the digital environment. And so one of the things I've been working on at the Copyright Office is building a system by which the Copyright Office can, and the Library of Congress, can get born digital serials content, journals, in electronically, right? And a lot of these issues are coming up in that context because we're getting all this content electronically, and as you all know in the audience, there's no standard for digital content. We pretend there is, like everyone talks about EPUB for books, but we all know that's not. I mean, that's a standard, but it's far from clear that that is the standard. So with these digital serials, we get a lot of XML content, for example. Not clear to me XML is going to be the dominant format for that content in 10 years, in 20 years. Books, Kindle has proprietary DRM on it. That's great if Amazon's around in 30 years, but when we're trying to build the national collection, or just take it out of the Library of Congress for a minute, any library is trying to build a collection that lasts a long time. Having this digital content in a way that they may not be able to get at it down the road because there's some proprietary system they need that's no longer in operation is sort of, it's difficult. It's antithetical to what a library is trying to do. So we're looking in the context of 108 and the library more broadly is looking at ways of accommodating that. And this is things like born digital works, digital preservation. What is a backup copy? We had people the other day, I was talking to somebody talking about, there's a libraries, I guess, use a 3-copy rule where there's the access copy, a backup copy, and then another backup copy. And they were talking about doing their digital access copy. In a digital space, the cost of producing another copy is zero, which is part of the problem, or part of the challenge for rights owners. But in the digital space, what does that mean? I mean, should a library be allowed to make 3 copies? Should they be allowed to make them available to people? What does access mean in the digital space? When it's a book, it's easy. The Section 109 of the Copyright Act says that if you sell the physical good, you don't have any control over that as the copyright owner. You have control over the copyright in that, but not over the physical good. But in digital content, it's one and the same. So if you have library, we get calls all the time from researchers who don't understand why our digital collections are not available online. And it's because we'd be competing directly with the people who make them available online, right? I mean, Elsevier and Lexis and those guys would be very upset if we were making their journal content available on our website for free because we're a library. Right? But that's where libraries have to go, or they need to figure that out. And 108, I think, will help. So we've got a discussion document that we're putting out later this year on that, or actually maybe late next year at this point. So this is what I wanted to highlight. Here's some more dates for you. The Section 108 discussion, we're doing a public symposium here in New York at Columbia on November 2nd. And information on that is, again, on the website, if anyone's interested in that. And then of more interest, and I, again, strongly encourage everyone here to get involved in this, and the associations that are here strongly encourage you all to get involved as well. This Orphan Works notice was issued on Monday, and we literally asked, I think the language we actually use is input on the current state of play for Orphan Works, or simply put, what's changed since we last thought about this. And the deadline for comments is January 4th, and then reply comments a month after that, February 4th. I am not sure yet if we're going to be doing public roundtables. I suspect we will, and there'll be more information on that forthcoming. One thing I was remiss in mentioning earlier is we also have a newsletter service called Newsnet, creatively named, and you can get, basically it's an email blast for every time we do something. And so if you just go to copyright.gov/newsnet, you can sign up there. There's several categories you can pick from. But you'll get news of anytime we issue a Federal Register notice, anytime we issue a rule, things like that, you'll get an email about it. Very briefly, going to talk about, I was earlier setting up the structure for the discussion, and was talking about our priorities document. We have priorities in policy and priorities in administrative practice. This is sort of our role as the primary overseer of Title 17. And I'm going to talk about two of them: group registration improvements and accommodation of digital authorship. I will just, is anyone familiar with the DMCA 1201 rulemaking process? A handful. You're waiting with bated breath for the rule. I can't say too much about it except to say that it's due October 28th and we expect it to be on time. So read into that what you will. But that is almost done for this cycle. So group registration. How many of you who said you registered earlier are photographers? So that's like everybody. All right. And how many of you have done group registrations on paper forms? And how many of you have tried to do group registrations online? Tried. Okay. So we're working on it, I promise you. One of the problems that we're facing, both from a policy and a technical perspective, is that this new copyright economy that we're in, I've said it before, as Sam said earlier, we're creating a lot more content, and the way that content's being distributed is different. And that's compelling us to think about how we register that content. In the photography context, we get a lot of photographers, perhaps some of you in this room, that register. I call them card dump registrations. You do a shoot, you come back, you offload your cards, and then you send them all to us to register. And so we get these group registrations with thousands of images in them. And for reasons I described earlier, there's sort of a policy issue with, what does the record say? How does the record say it? But that comes up in other spaces as well. Think about blogs. How does a blogger register their work? Do they have to register every blog post separately? That seems onerous. But at the same time, how do we set up a registration system where you can register at some reasonable interval, and it sort of, the record captures the fact that you're covering multiple days worth of entries? You have authorship issues with, blogs often have multiple authors. Are they joint authors for all of the blog content? How do we illustrate that on the public record? How does the system accommodate that when you submit it? What is the deposit copy like for a blog? Do you have to send us the website? Can we just scrape it from the blog? If that's the case, how do we accommodate the fact that you might change it after you registered it? All these sorts of things raise serious policy questions for what the record needs to look like, what the record is supposed to do, and also technically, how do we accommodate just getting the stuff in? And there's two pieces to that. One is, we look at these deposit copies for the purpose of making sure it's copyrightable work so that we can legally grant you a registration. But it's also, again, the source of the library's collections. And we're kind of working out, those of you who have registered are familiar with the phrase best edition. What the best edition has changed dramatically in the digital environment. And for some things like blogs, it's very difficult to figure out, what does that mean? They're very important. I mean, think about the political context. A lot of our political discourse this time around is happening on Twitter, it's happening on Facebook, it's happening on private blogs. That's important. If you're a librarian or historian focused on those areas, that's an important piece of American history, and we need to be able to accommodate that. So that's part of this discussion, is figuring out how do we put all that into a robust public record, and how we accommodate it from an administrative side. I sort of hit on these already: online content, websites, and blogs, and things like that. New distribution models. There are areas of the Copyright Act that make a distinction between published and unpublished works. And I know a lot of photographers don't like that, because it's very, photographers in particular, because it's unclear, right? Whether if you put it on a blog, you've published the work or not. And it has implications for the way you register those works. But it also raises other questions, like a print-on-demand book that's never been ordered. Is it published? It's offered for sale, which is one of the requirements under the statute. But if it hasn't actually been distributed, it exists only in Amazon's database and on someone's hard drive. How do we handle that? Do we require that you submit us 2 copies? Like, do you have to then have 2 copies printed to submit to us for registration? Or can we just take the manuscript and treat it as an unpublished work? And that has the distinction between published and unpublished is relevant in certain areas of the Copyright Act. And a big one is fair use. The jurisprudence that's evolved over the years about fair use treats unpublished works differently than published works. So it's a relevant distinction. I've heard some clamoring about from people that want to sort of get rid of the distinction. And my personal view is I think that's dangerous. We don't have an office position on it or anything. But I will say we're working on updating our compendium of copyright office practices, which is a major, it's basically our practice manual for how we go about running our registration system. And in that, we expect to have some guidance on publication, at least for the purpose of registration. That particular document is important because it not only tells us how to do our jobs, it will become the document that courts look at in determining whether registrations are legitimate, and in other contexts where the courts would defer to guidance from the expert agency in that field. All right, I think I've hit all those points. All right, let me move on to some of the special projects, and I'm going to talk about two of them. One of them, please don't throw things at me. I'm going to talk about the fee study a little bit. The statute I mentioned earlier, the statute requires us to recover our costs, and we tend to operate on a 60% fee recovery basis. We issued a while back now, back in March, a proposed new fee structure, and as you might guess, the fee we proposed to increase most of the fees, although we did throw a bone on one thing. I'll show you in a minute some of the highlights. Public comment on that is now over. There may be some other opportunities for engagement. We're still working through some of that. But basically, the current fee for an electronic claim is $35, and we're proposing, these are just proposals at the moment, nothing's been set in stone, that would go up to $65, which is the current cost for registering on paper. The bone we threw is that if you have a basic claim filed electronically where the author is the claimant, and it's not a work for hire, that would only be $45. And then paper claims would go up to $100. And I'll just one of the issues with paper claims is that they are complicated from a technical perspective because we put those into our electronic system, but the system that handles the paper is a legacy system, and so getting those to talk to each other can be challenging sometimes. The legitimate comeback I hear from, particularly from photographers whose groups have to be done, certain group registrations have to be done on paper, is that this seems sort of unfair. You're charging us more, but you're not letting us register online. That's a legitimate criticism, and we are working on, as I just described, we're working on ways of improving group registration and photographic registration online. So I hear you. I don't have any answers on that at the moment, but we're very, very aware of the issue and the disparity. So let's talk a little bit about our registration system. We're engaged right now in ongoing meetings with stakeholders and related organizations on what our system does, how it works, and how it could be better. And as you can imagine, they're long meetings because there are a lot of ways it could be better. We know that we think our current system, because it was put in place in 2007, largely without much public input, I think of that as sort of registration 1.0, and we're trying to build registration 2.0. And it's an evaluative process. It's slow. It can, from the outside, can seem very tedious, but it's extremely important to us that we get public input from everybody, and I mean public input. So not just the major stakeholders. You know, there's a question earlier about the impact of Google. Google's a major player, but we also want to hear from independent creators. We hear from a lot of independent photographers a lot. We like that. We hear from the associations a lot. We need more of that. But we really want to get a full picture of what our registration system should do. One of the challenges of being a government agency is you really do have to be, or try to be, all things to all people. And it's very, very difficult. And so a lot of times, talking with someone earlier who was frustrated at the fact we've been talking about doing, you know, one of the things we're thinking about are how you can set up better interfaces with our system, like an API. And I you know, as a photographer myself, this comes up all the time. Why can't I just click a button in Lightroom and have it register my images, just like I can click a button and have it published to my photo hosting site? I can publish to Flickr or Photoshop or whatever. And that's a great question, and it's something that we need to work on. But the challenge for us is we have to be vendor neutral, right? You don't want us building a system and saying, well, you've got to be using Lightroom. Aperture users are out of luck, right? That kind of thing. We can't do that. We need to hear from everybody and build a system that accommodates everybody. And I promise you that photographers are not the only people clamoring for an API. There's lots of people that would love to have access to our records through some sort of API, B2B solution. It's all on the table. It's all stuff we're thinking about. I'm not in a position today to sort of tell you that that's going to happen or that we're going to prejudge that as the best solution, but it's something we're aware of. It's something we're thinking about, and we're continuing to have the conversation. And I want you all here and organizations represented here to be a part of that discussion. Another piece of that, just to wrap up very quickly, is application information capture and metadata capture. We require, again, using photography and visual arts as the example, we use a lot of we require, for example, people to submit a title for their photos. Well, why can't we just extract that from the metadata? I mean, there's a pretty widely known standard now for metadata. Why can't we just take that out of there? There are, again, the issues with the validity of the data and things like that, but I think those aren't necessarily insurmountable. And so we're looking at ways of doing that also. So you wouldn't have to individually title things. We could pull that out. We could pull out, the exit data and identify, when the shot was taken and add that to the public record. Add lots of additional information to the public record, which, and this all relates back to orphans, because the more information we have on the record, the less likely the work is going to be orphaned, because you've got more data points to sort of triangulate and find the source of that content. So it all sort of fits together, and it is slow going because we have to be deliberate. But I promise you we are working on these issues. And that is, I think, yes, that is about all I have, unless there are questions, which I'm happy to take. And I'll put up, I've got my contact information. There we go. Feel free, that's my direct line and my direct email. I check my own voicemail, I read my own email, so please feel free to contact me. It's a question with that.
Yeah, I think the U.S. is the only, or one of the only countries that has a registration system for protecting copyright. And since we can agree that suing without prior registration is usually not worth it, because if you're only going to get actual damages, you're back where you started from, and it's not going to be enough to pay for your costs. How do other countries solve this problem without registration? In other words, we're alone in this registration process, which obviously gives a lot of people a lot of grief. What can we learn from these other countries, or is there something special about our system that this registration makes sense, where they don't need it over there?
So the question was, we're one of the only countries in the world that has a registration system. We have these issues with small claims and people who don't register not having access to meaningful enforcement. And effectively, how have other countries handled that? Fair characterization of your question. The answer is many other countries are actually thinking about trying to figure out a registration system, because they're having the same issues that we are with respect to orphans and people wanting to use content but can't find the owner or the contact information for the owner. And what's known as the Hargraves report in the UK proposed a digital copyright exchange, which would, it's not quite a registration system, but it would function similarly. And we host, part of our international work, we host delegations from all over the country, all over the world, asking us about registration systems. You have an add-on?
Just follow up on that.
Yeah, sure.
The Orphan Works issue to the side.
Yeah.
Because that's a special case now. We've had this registration process for years.
Right.
And I don't think it was created as a solution to the Orphan Works problem. The Orphan Works problem is going to happen no matter what. Because the kind of works that are Orphan Works are the works that generally aren't registered. That's why they're Orphan Works in the first place. So that will continue to happen. The reasons why the Orphan Works will continue to be the reasons why the Orphan Works with or without a registration system.
Well,
in other words, we've had this system uniquely for many, many, many years before even people thought about it.
right.
And I still don't understand why we need it.
Talk about the statutory damages. The trade-off is there's
Well,
statutory damages.
Yeah, that's right. I mean, other countries, that's the litigation answer, is that there aren't statutory damages in many of these other countries. And so the trade-off here is if you register, you get to have statutory damages, which, some of the litigators in the room will tell you that's a huge benefit to not having to prove your losses, or your lost profits or the profits of the infringer. You get this sort of ability to immediately collect, up to $150,000. That's the public interest trade-off, is you're creating a public record of the work for the public benefit in exchange for getting the enhanced damages. We also get an attorney's fees. I didn't mention that earlier, but you can't get attorney's fees unless you timely register your work. So we built in incentives for people to register as the quid pro quo for the statutory damages. I mean, it sounds like, I don't want to put words in your mouth, but if you're saying we should get rid of statutory damages and then get rid of registration, that's a valid thought. I don't think it would have much traction with stakeholders, to be honest, just to be
That's because the Copyright Office wants a copy of every publication.
No, I mean, for us, the question was, if the driver is that the Copyright Office wants a copy of everything. The law requires that anyway. The registration is one way you can satisfy the mandatory deposit provision. But if it's published in the United States, you're technically obligated to send us a copy of it. So. We go back here first.
Can you expand a little bit on the requirements on published and unpublished for photographers? I'm getting a lot of questions from photographers. We're trying to register legacy works from years past because they've never registered it.
Yep.
Now they're understanding the value of registration. And they're thoroughly confused, and the Copyright Office doesn't seem to help much on changing published requirements, sometimes without telling people. Are there any plans on trying to make it easier for photographers to publish the body of our work? Because we're pretty much a put-upon group of copyright holders as far as how much work we produce and how we have to register it.
Right. Yeah, that's related to this overarching study we're doing with, or evaluation we're doing with the registration system, as well as the compendium of Copyright Office practices. We're working on, I was actually in a meeting before coming here last week, about that very issue of improving that approach. I don't have any answers for you today, but it's on our radar. We're aware of the issue. So I'm happy, if you're looking for specific guidance on how to register something today, I'm happy to talk with you after about that if you like. So lots of hands. So I think you were next, ma'am.
You had mentioned early on in your talk that you were looking at a number of things to rectify, including a row of websites, illegal streaming, and specifically the legal treatment of pre-1972 sound recordings.
Yes.
Is that date also applied to photography and printed works? And is it moving along as in a block of 40 years? Does it continue to move on, or is that a set date?
The pre-72 sound recordings, the question was to essentially expand upon a little bit the pre-72 sound recording study that we did. There's an oddity in copyright law that basically said sound recordings that were fixed before February 15th, 1972 are not subject to federal copyright protection. Many of them have protection by various states. And so users of those works are challenged by having to sort of navigate this patchwork of 50 state laws, some of which are actually criminal. And so Congress asked us to look at, would there be some benefit to federalizing those works? And just a quick spoiler on that report, yes, we suggested that they do that. And there are issues with it, though. It's sort of, well, how long does the federal protection last? Do we set the date? How do you fix the date? What are the notice requirements? How do you register them? Those are all, it's more detail than I'm prepared to go into today, but it's all in the report, and I'm happy to talk with you offline about it if you like. But yeah, it's specifically to sound recordings, and it's in the law, which is why that date was relevant. So, but no, photography's been protected consistently since the beginning of certainly the current act, and I forget when they added photography as a unique class of works, but I think
1965.
Was it 65? Okay, yeah. So I mean, photography's been consistently protected since then. Visual art. Yes.
In my will, I have left the bulk of my estate to the Aesthetic Realism Foundation, which is a not-for-profit educational organization. Do I need to have an additional document of transferring the copyright from me to that organization?
If it's not clear in the will that you're transferring the copyrights and not just the physical content, I strongly recommend that you do that to make it clear. The question was, if you're giving copyrights in a will, do you need to have a separate document that articulates that you're transferring the copyrights? The way those often work is you have the will, and then there's an addendum that has the copyright transfer, and that addendum gets filed, it's executed, and then it's filed with us at the Copyright Office. Let's talk about a recordation system. That's the kind of thing that gets recorded. That's so people can find who the current owner is. So when those are transferred, somebody will be able to identify them, the new owner, as the owner. So,
Thank you very much.
sure, no problem. Lots of questions and only a few minutes left, so let's do right here first.
Will you explain fair use?
You missed that we only have a few minutes. That was a question, just explain fair use.
I have clients who say, I can publish this because it's fair use. And I want to be able to answer, well, this is why you can't. Or maybe you can. But I've never completely understood that argument.
Yeah, so many people don't. So fair use was intended as it's a cliche term, but it was effectively a safety valve to ensure that people couldn't hold up speech by saying it's copyrighted. So there are certain limited circumstances that are not defined anywhere. It's just we consider them based on 4 factors that are set forth in the statute. And it's section 107 of the Copyright Act, 17 USC 107, that balance the competing interests of the public good and the market for the work that's being used. It has been my experience that the vast majority of times that somebody wants to use something and says it's fair use, particularly in a commercial context, it isn't actually a fair use. That is not a blanket statement. The challenge with fair use is you don't really know whether it's fair use until the court tells you whether it is or not. And of course, to get there, you're several million dollars in the ground, and you've got, people complain about that and say, well, we need some bright line rules. But the virtue of that is, of not having bright line rules, is that you have the flexibility. And it's a challenge, and this is another thing that's very unique in our law. Most other countries don't have a fair use. There's some permutations of it, but fair use is so intertwined with our First Amendment jurisprudence that it really is unique to us in the United States system. But it is the biggest thing you can tell somebody is that it is a case-by-case analysis that requires considering the facts of that particular case. And you can't, there is no blanket rule. There were guidelines when the 76 Act was passed, but they're, in the digital age too, they're not that useful anymore. So the key thing to remember is that it's intentionally amorphous, and it's a case-by-case discussion or analysis. Sorry, that's not very satisfying, but absent facts, that's the best I can do. I think this will have to be the last question.
Yes, earlier someone said that most of the orphan works come from unregistered works, but I get published and the publisher puts photos online, all metadata is stripped. I know that I'm part of ASPP, I know ASPP is involved in approaching software developers, but what is the Copyright Office dealing with in terms of the source of some of the missing information, and how that's disappeared?
Yeah, it's a challenge. I mean, how we're dealing with it is it's an issue we're aware of, and it's pervasive. I mean, we have to think about that in the context of registration. But I'm glad you mentioned that, because I know that the social media networks, I think, unless they've changed their practice, are all pretty well known for stripping the metadata. I think Facebook strips all the metadata out of images that people upload, and so you get somebody that right-clicks, saves that image, and then uses it for something else. It's a lot. I mean, at that point, it's effectively become an orphan because it's very hard to track down that original person. But yeah, it's a problem, and I think it's something that the tech sector will eventually help us solve by. Somebody told me Canon had an application that could check the metadata in an image and determine if it's been modified since when the camera wrote the data. I don't know if that's true or not, but that type of technology, I think we're going to see more of that as this becomes a bigger issue. There was an article the other day about how metadata is being used now as evidence in court cases, the time and date of the picture being taken, things like that. As that becomes more accepted, but the general, everyone in this room, but certainly the photographers, know that this metadata is out there and that there's a lot of rich information in the metadata. The general public and certainly judges are just now figuring that out. As soon as it becomes a more mainstream thing, there will be ways, I think, the market will develop ways and tools of protecting it, or at least identifying if it's been spoofed or stripped and things like that. And I will point out, I forgot about this until the other day, but it's actually illegal to take metadata out. Copyright management information is the term under the DMCA. It's illegal to strip metadata in the course of committing an infringement. And so the issue for the social networks is if you've got sites like Facebook that are doing it under the terms of service. If I go onto Facebook and I upload one of my own images, I've given them a license to use that image, or to use that image to the extent they need to display it on the site. Them stripping that metadata probably isn't illegal, and this is just a quick off-the-cuff analysis, but my sense is because they're doing it pursuant to a license, I'm not sure it's illegal for them to strip the metadata in that case. It's different if I've taken one of your images and unlawfully posted it to Facebook, and they've stripped the images out. That gets into this murky thing because it's me committing the infringement, not Facebook. So it's a legally complex area, but it's a valid one. And as I say, I think the market's going to help us sort that out, but we'll see.
PickScout has a new service that's doing.
Oh, did it? PickScout? Okay, new service. Okay, so it sounds like there's already some commercial stuff being developed in that space. So I know I said that was the last question, but We're at 10:56. Can I, one more? One more question. I'm being told by the organizers, one more question. And the lady there in the back was the first hand I saw, so.
I just wanted to ask a question regarding what you just said about if you took this video and uploaded it to Facebook, that would be infringement. So is it considered, this is something I struggle with, is it considered infringement to take somebody else's work and post it on Facebook and attribute it to them, like as a, this is what so-and-so, like like even an article or a music video, or is that really considered infringement?
So the question is, if I post something to Facebook that I didn't create myself, is that really infringement? The social networks are all very tricky because if you're actually uploading it, my view, again, without any details of the relevant facts of any particular circumstance, in general, it seems like when you upload something, you're creating a reproduction of that work. It's a violation of the reproduction right, which is exclusive to the copyright owner. There may be exceptions. Under certain circumstances, it might be a fair use, although my suspicion is in most cases it isn't. It's different, though, than if you're linking to something on Facebook. So, for example, I post my photography on a third-party site that has, frankly, better terms of service that I like, and then I post a link to that site on Facebook. So that way, Facebook isn't actually getting the image. They're getting a thumbnail of the image at that point, because they'll pull that in from the site that I'm linking to, but the content never actually touches Facebook. And I'm just using those as examples. There's lots of, Google Plus and Pinterest and all these guys. They all have slightly different ways of working. And that's one of the challenges, is each time you need to reconsider the use in the context of the site, and these sites change all the time. I mean, Pinterest, the legal community blew up when Pinterest launched because nobody was really sure what it was and how it worked and what it did. And there were all sorts of education events for lawyers to try to sort out sort of what the issues were there. It happens all the time. Every time there's a new service, we're trying to figure out where the liabilities are. So, again, sorry, it's not a very satisfying answer. It's kind of the standard lawyer, it depends.
No, I think it's a confusing space, especially since companies now use Facebook, where before it was like kind of a personal use, and now I feel like Facebook is almost certainly websites. So
yeah,
infringement elements are just very confusing.
Yep, and I think you're highlighting a major point, and I'll end with this, that the copyright norm, this is not my original thought, but the copyright norms, sort of the way we think and deal with copyrighted information, are very, very different now because of technology than copyright law. And what we're trying to do, if I had to say it in a few words, is we're trying to update the law to accommodate the uses and the context in which content's being used and created. So with that, thank you all very, very much. I appreciate it. I'll be around for